Hello, my name's Daniel Hill and I'd like to talk today about the state and marriage, sever the link. I'd also like to make it clear that my views don't represent the views of my employer, the University of Liverpool, in any way. The argument that I've made in the past, and there's hyperlinks to check if you want for where I have made it, are that the state should not solemnize or purport to solemnize any marriages, register any marriages, or even make any laws, civil or criminal, respecting marriage. Now I want to make it clear that that is not a proposal to abolish marriage. Rather, it's a proposal to free marriage from state control. Now, it's an assumption or presupposition of this argument that marriage is more than a mere legal contract. And in fact, the law itself has historically recognised this point. So Sir William Scott said in 1811, in the case between Dalrymple and Dalrymple, he said, "Marriage in its origin is a contract of natural law. It may exist between two individuals, although no third person existed in the world, as happened in the case of the common ancestors of mankind. It is the parent, not the child, of civil society." At the Reformation, this country disclaimed the doctrine of a sacrament in marriage, though still retaining the idea of its being of divine institution in its general origin. So I say that marriage predated the state, and Sir William Scott says the same there, and I also want to add that it can still be contracted outside the purview of the state. And it's the couple that contracts the marriage. All the state does is recognise that the couple's contracted the marriage. Let me give a very, very brief historical background. In England and Wales, government regulation of marriage came in only with Lord Hardwicke's Marriage Act in 1753, and government registration came in only in 1837. In Scotland, just for contrast, though most of what I say today will be couched in terms of England and Wales, government registration of marriage was not introduced till 1854. Now, before 1753, in England and Wales, marriage was under the care of the church. The secular authorities did occasionally take cognizance of marriage, for example, prosecuting bigamy, but until 1857, the government deferred to the church about who was married to whom. There were special exemptions for people of the Jewish faith and Quakers, but in general deferred to the church. So here's an abstract of the argument that I gave in those hyperlinked places before. It's a fact that the state discriminates against unmarried people in various ways, for example, in the marriage allowance and distribution of property on separation, and other ways as well. My main premise is this: it's never necessary for the state to discriminate on grounds of marital status. Many people unmarried in the eyes of the state have just as good relationships as far as the law need be concerned as many of those that are legally married. Now, although the United Kingdom has been reducing discrimination by treating cohabitants equally with legally married people in some areas, so for example benefits, tax credits, some tenancies, discrimination on marital grounds remains in some areas. I just named a couple of them at the top here. And when that discrimination is gone, then I say there'll be no need for the state to register or solemnize marriages. Okay, that's an abstract of the argument. Now I want to direct our attention now to the situation in family law in Australia and New Zealand. This is what Section 4AA of the Family Law Act 1975 in Australia says. A person's in a de facto relationship with another person if A, the persons aren't legally married to each other, and B, the persons aren't related by family, and C, having regard to all the circumstances of their relationship, they have a relationship as a couple living together on a genuine domestic basis. And as a similar definition that holds in New Zealand, see Section 2D of the Property Relationships Act 1976. Now, de facto relationships in Australia and New Zealand do not have to be registered. But New Zealand and most of Australia, so for example New South Wales, do provide for the registration of relationships outside that framework of legal marriage. The Northern Territory, by the way, in Australia provides for applications to the court for declarations of the existence of a de facto relationship, so that's a little bit different. In New South Wales, registration is by means of a statutory declaration that one's already in a relationship, and registration can be done online. It's a very simple process. And that's different from the way civil partnerships work in the United Kingdom. In the United Kingdom, civil partnerships are legal creations. They're deemed to begin at registration, and they're registered in approved premises in front of a registrar and 2 witnesses. So they're not registering things that are already been in existence, that the couple brought into existence. The idea is that they're things that begin in this special defined way in a special defined place. Now, one area in which there's a discrimination in the law, but also where my critics say there has to be discrimination in the law, is intestacy. So I want to discuss this and argue that there is a way forward here which does not require the legal recognition of marital status. Intestacy law in England and Wales is discriminatory. A surviving legal spouse or civil partner stands to inherit automatically if their spouse or partner dies without having made a will. But the partner not in a legal marriage or civil partnership has got no right to inherit if the partner dies without having made a will. Now, under the Inheritance Provision for Family Independence Act 1975, a legally unmarried partner may apply for, quote, reasonable financial provision, unquote, from the deceased's estate if they've been living with the deceased for 2 years before the death. But success is not guaranteed, and reasonable financial provision means such financial provision as would be reasonable in all the circumstances of the case for the applicant to receive for his or her maintenance. And that takes account of the applicant's assets. So in other words, it's not a matter here of saying, what would the deceased have wanted? Would the deceased have wanted all his or her property to go to their partner? No. The point is that it's about what people might need for maintenance. And that's very different from if you're legally married, because there, if the partner dies, if the spouse dies, then the surviving spouse can and usually does inherit anything, at least if there's no children, in a case where the spouse dies without having made a will. So this is discriminatory, but I want to say it needn't be that way. Let's look at how they do things in New South Wales. The Succession Act 2006 in New South Wales allows those with registered relationships, these relationships I was just talking about a couple of slides ago, to inherit in just the same way as married people. Secondly, it allows those in unregistered de facto relationships that have obtained for a continuous period of 2 years or have resulted in the birth of a child to inherit in just the same way as married people. I think that's a good idea. A qualifying period seems advisable, though it's possible to contract out of some of the financial effects of being in a de facto relationship. And of course it's possible to make a will. So if somebody didn't want to their partner to inherit, then they can make a will and they can leave their money wherever they want to. Now, the Commission on European Family Law has also drafted some non-binding, quote, principles of European family law regarding property, maintenance and succession rights of couples in de facto unions. This came out in 2019. Principle 524, succession upon intestacy, says, quote, in cases of intestacy, the surviving partner, so that's a partner of somebody that's been in an unregistered legal relationship, relationship not registered at law, in the case of intestacy, the surviving partner has the same right as a spouse to succeed to the estate of the deceased partner, provided that he or she was in an enduring relationship with the deceased at the time of death and had been so for at least 5 years, and with whom he or she has a common child. So it's a bit different from the law in New South Wales, which I prefer, but as you can see, it's still saying that there should be provision for people that aren't legally married but have had this kind of enduring relationship with the deceased to succeed to the estate, not merely reasonable material provision, but to succeed to the whole estate. Now, I think there's a lot to learn from those two examples, New South Wales and Sever. Under my proposal, the state would register no marriages. That's what I said right at the start. But there would be the option of registering a relationship. and registered relationships will be treated as marriages are now for purposes of intestacy and lots and lots of other purposes as well, immigration, just to give you one example. Unregistered de facto relationships will be treated as marriages are now if they've lasted for 2 years or produced a child for purposes of intestacy and relationship breakdown and other purposes as well. We didn't go through all of them now. Note again here that these relationships are not creatures of the state. These are antecedent relationships. They already exist. The state's merely recognizing that fact, and you're merely registering the fact that the relationship already exists. Now, you may have some objections here. You may say, what about the children? You may argue that the state needs to register all relationships in order to protect children. Well, of course, absolutely I agree. Protection of children is very important, but not all the people that are married or in a civil partnership have children, and not all parents are married or in a civil partnership. Indeed, registration of children is a separate legal duty on all parents, whether or not they're married. Now, my proposal, registration of children, then would be basically unchanged. You might wonder about bigamy and polygamy. On my proposal, the law against bigamy would cease to be operative because the state wouldn't recognise any marriages. Here's a quotation from a publication in the Parliament of Australia. Australian law recognises both marriages and de facto relationships. While bigamy is a criminal offence, it is not an offence to have multiple simultaneous de facto relationships. Polygamous, quote, Islamic marriages, unquote, are not legal marriages but may be recognised as de facto relationships. Now, a person can't register more than one relationship in Australia or New Zealand, but the state can recognise more than one de facto relationship per person in Australia and in New Zealand. So you can see there's a different way to, even if you don't have a law against bigamy, you can recast the principles in terms of registration and recognition of de facto relationships if that is the desired policy. You may worry about the law about incest. Now, my proposal, the law banning marriage or civil partnership with a close relative would cease to be operative. But that doesn't follow the state would have to recognise de facto relationships with close relatives. Australia and New Zealand do not recognise those relationships, and the state could criminalise the registering of a relationship with a close relative if it wished to. An incest, sexual intercourse with a close relative would, on my proposal, remain a crime. You may worry about forced or child marriage. I say that these very important laws, the laws forbidding forced marriage and marriage of the under-16s, should remain. Now, these already apply in England and Wales to all marriage ceremonies for under-16s, including those that aren't intended to form a legal relationship under English and Welsh law. I say that the state should not recognise as de facto relationships forced relationships or those where one party is underage. And I also say the age of consent should be no lower for being in a relationship, either de facto or registered, than it is for sexual relations. Now, I've said that the state discriminates against the unmarried, but the actual law, funnily enough, says that you can't discriminate against married people. Being married or a civil partner is a protected characteristic under the Equality Act 2010. And I say funnily enough because it doesn't go both ways. It doesn't protect the unmarried. And you may worry, well, what's going to happen to this law under your proposal? Well, the point is that the Equality Act 2010, the force of that does not depend on marriages being a legal status. The Act also protects race, religion or belief, and sexual orientation, even those are quite rightly not subject to government registration. So this provision of the Equality Act 2010 will continue to operate just as now under my proposal, and I think it should be extended to cover discrimination against unmarried people as well. Finally, the European Convention on Human Rights. The European Convention on Human Rights provides in Article 12 for the human right to get married. Now remember, I'm not proposing to abolish marriage, I'm proposing that marriage should be set free from state control. Is that proposal compatible with the European Convention on Human Rights? Well, there's no case law here, but I say that it should accord with the European Convention on Human Rights, provided that, first, nobody's being prevented from getting married. Secondly, nobody's marriage is being unfairly privileged by being afforded state recognition while others are not having their relationships recognised. Thirdly, provided that nobody's being prevented from accessing state benefits or privileges that they would have got consequent on state recognition of marriage, and finally provided that significant relationships are recognised by the state where necessary. Now my proposal meets all of those, so I maintain that it should pass muster with the European Convention on Human Rights. That's all from me. I want to thank Julian Rivers, Sarah Spear, Rebecca Probert, Frank Cranmer, James Heather, Pete Williams, Lorraine Kavanagh QC and Pauline McHugh. Thank you very much to you for listening, and I look forward to comments that people might have.